All right, thank you. I hope everyone had a good lunch. My name is Matthew Alexander. I'm a second-year law student here at Colorado Law, and I have the pleasure of introducing you all to the panelists of our next discussion, the new federalism. Beginning with our moderator for this portion, we have Mihir Kshirsagar. Mihir is the clinic director of Princeton University's Center for Information Technology Policy. First on the panel is Nicholas Degani. Nick is the chief strategist and co-founder of the Digital Progress Institute. He's also an adjunct professor at the Antonin Scalia School of Law at George Mason University. Next up is David Don. David is serving as the senior vice president for public policy at Comcast and has worked on public policy and spectrum allocation for over 25 years. Apologies. We also have Lisa Hone. Lisa is Chief Democratic Counsel for the Commerce, Manufacturing, and Trade Subcommittee of the Energy and Commerce Committee in the House of Representatives, and she's formerly a senior fellow here at Silicon Flatirons. This panel will also feature Chris Lewis. Chris is President and CEO of Public Knowledge and had served as Deputy Director of the Office of Legislative Affairs at the Federal Communications Commission. And finally, I struggled figuring out how to properly introduce the presenter for this portion, Attorney General Phil Weiser. Notably, Attorney General Weiser founded the Silicon Flatiron Center for Law, Technology, and Entrepreneurship and is formerly the Dean of our law school. With that, I'm going to pass the podium to Attorney General Weiser. Thank you.
It is a real pleasure to be here. Congratulations to Brad Bernthal and the entire Silicon Flatirons team for once again assembling a special group. Often feels like a family reunion because many of us come back year after year. And I was just talking to John Nectarline about the interesting dynamic about some issues remain enduring. I'll talk briefly about three as a overview, and mostly I'm excited for the conversation we're going to have to follow. The first point, cooperative federalism, something that I have spent much of my career thinking about working on. Secondly, the work at the state level on privacy, and I know we've got at least one or two people from our office who've worked on this, and they've also enlisted Paul Loam to help. And third, social media, something very much on my mind that requires our attention. Cooperative federalism is an essential proposition that the best form of governance is not one where the federal government occupies the field or one where the federal government is irrelevant. More and more issues have spillovers, benefit from some form of standardization, but also benefit from experimentation and the ability of states to develop unique approaches. The environmental laws of the 1970s took this model to heart. The Telecommunications Act of 1996 followed suit, and most recently the Affordable Care Act also follows this model. There are some who may argue that there is something problematic about this model, blending state and federal authority. I find it to be now both previously been a scholar of it, now a practitioner of it, incredibly sensible. And the earlier work I did on this started from an important proposition, which is under the 10th Amendment, the federal government cannot commandeer or compel state participation. They can, however, invite it, and if the states see the framework as one where they are willing to take part, they can, and that indeed has been the case in the telecommunications context. There are a lot of forces trying to blow this model apart and, frankly, to blow up the regulatory state. One case at the U.S. Supreme Court this spring involves a principle known as the non-delegation doctrine. Many people recall fondly, as do I, Judge Steve Williams, formerly of this law faculty, D.C. Circuit Judge, and a regular at these conferences. Steve, as he insisted on being called, wrote an opinion for the D.C. Circuit in the American trucking case that sought to revive this non-delegation doctrine. Anyone know what the Supreme Court's ruling was rejecting it? 9-0. This principle is back. It's back in the telecom context, and it would blow a hole in the cooperative federalism nature of the regime we have for telecommunications. What it would say is the FCC was given too much authority by Congress to develop an explicit form of universal service subsidies, and maybe the FCC's reliance on a nonprofit Universal Service Access Corporation is some illegal delegation of authority. If you don't allow Congress to, I'll quote a famous case, allow administrative agencies to fill up the details, then it's going to be hard to have any regulatory systems. Congress cannot generally act, particularly in evolving areas, thoroughly and prescriptively. They have relied on administrative agencies to do so. The question in this case is, will we revitalize this doctrine, which had a brief appearance in one case or two in the 1930s, but basically hasn't been used? See American Trucking. We filed a bipartisan brief, Colorado led it, making the case that the universal service system is critical to affordable telecommunications service in many contexts, including wireless and broadband, and it would be devastating to this industry to undo it. We can have lots of policy discussions, lots of administrative management discussions about how to better do universal service. That's not this case. This case is whether the entire regime gets blown up and the states are on our own without a partnership with the feds. I also want to talk about antitrust law because it too follows cooperative federalism. One of the important episodes of the last year was a party, Kroger and Albertsons, who were trying to merge, argued that a state, in this case Colorado, lacked authority under our constitutional system to challenge a merger on its own in state court. The federal government, respecting the cooperative federalism nature of the antitrust laws, filed a statement of interest in Colorado State Court through the Department of Justice, making plain that states exercise their sovereign authority to enforce antitrust laws, and they do so whether or not the federal government is in the case. That was an important principle, and it's, to me, critical to what cooperative federalism means, which is the states get some slack to operate, and the feds can't just snuff out the role of state authority. Let me talk about privacy because it is a very critical case study. I want to stipulate, and not every state AG will say this, but I have and I will again and again. The best world that we can live in is one where the federal government passes a comprehensive data privacy law. Thank you for being the only crowd that will give that a round of applause. The Obama administration, a number of us were part of this, put out a privacy bill of rights circa 2012. Some basic principles about the importance that consumers have awareness and control over how their data is used. Something that is deeply believed across both sides of the aisle and in every state in the union. Congress has failed again and again and again to pass a data privacy law, despite bipartisan support, despite it making so much sense, despite every nation in the world practically having such a law. So what's been happening? State after state after state are passing these laws. Ann Lee's here. She can help me. What number are we up to with states? Do we know? I was going to say 15, but that's directionally correct. It's going to get to 50. That's what happened with a data breach law. We don't have, and by the way, the idea when you pass a federal data protection law, it would include the data breach. So you'd harmonize the standards. What I live in fear of hearing from a company is I can comply with Connecticut's privacy law or California's, but not both. And the risk is, and I've tried to preach this, if a state has
prescriptive privacy requirements, you have to give notice in this font, we're toast. Because what do? It's incredibly burdensome and it doesn't make sense. Instead, we need, and this is something we got to work with at the state level, what I'll call, bless you, principle-based. You have to give effective notice. We also, in Colorado, for example, have a data protection assessment requirement. We're not prescriptive about every single way it has to happen. We just say it has to happen in a meaningful way. So companies are asking, how much data are we storing? Who has access to it? How long do we keep it? We have a burden that all of us on the state level have to work on, making sure our privacy laws are interoperable. And all of us as Americans need to do our part to build towards effective functioning national governance. We're passing laws like ones on data privacy can happen again. Which brings me to my final point, social media. How many people here saw the movie The Social Dilemma? The rest, I strongly recommend it. When the Surgeon General wrote an op-ed and talked about our youth mental health crisis, he talked about a Coloradan, Lori shot. Lori lives in Sterling, Colorado, eastern part of our state. I've had the chance to get to know her. And she has told me about her daughter, Anna, who died by suicide because she was going down dark holes on social media. The way social media platforms are largely designed to maximize engagement. How much time can they get people to spend on the platform? Social media companies have marketed to people under 13 years old because you get them young, you keep them longer. They've had a constant stream of alerts, including all night, so kids aren't sleeping, including during the school day, they're not concentrating in school, taking them down dark holes like Anna, such that now young girls are twice as likely to engage in self-harm as other people are, or to see self-harm content as other people are, rather. We're not in a good place. The kids are not okay. If we had a high-functioning national government, we could pass laws to protect kids from these harms. But we don't. So state AGs, all of us, are now in litigation against Meta, investigating TikTok to change how these platforms operate. This is not something that we should be dithering on because we know the stakes are so high. Congress may or may not become functional anytime soon and be able to pass a law on social media. But states are functional. But here's the problem. Section 230 is being used in a way that I will say those of us who remember why it was enacted, when it was acted, would never have guessed. The idea, which I totally believe in, internet platforms should be open to speech from a range of quarters, and those who are merely a passive conduit, think Craigslist, aren't liable for the speech that's on there. Now, what we're seeing today with massive media companies whose algorithms are giving content just for you, how about you check this out, are not passive in any sense of that word. They are active. They are marketing for purposes of engagement, knowing who you are, and sharing content that they know can harm you. So we're in litigation on that issue, and we are looking at legislation that will provide more forms of oversight and accountability. But I will say this, we've already run an experiment on our kids over the last decade. You give them all smartphones, you let them spend 5 hours a day, which is the average on social media platform. What's going to happen? The early results are not good. We all need to lean in and look for how we address what is a true national crisis. Thank you.
Thank you, General. Thank you, General Weiser. Is this on? Okay, good. For those remarks, appreciate this. One of the nice things here is I'm going to start with, as a response, I agree with a lot that you said. I will say I think it is a travesty in our nation that Section 230 of the Communications Act and the First Amendment have gone from being shields for good faith work and for those who are trying to protect themselves from avaricious lawsuits into swords swung by technology companies to get out of responsibilities, to pretend that the horrible things that they are doing are entirely someone else's fault and cannot possibly be remedied by we, the people of the United States. And so I applaud states like Colorado and others who are beginning to step up and push back and recognize that the what I will call blind maximalist understanding of Section 230 and the First Amendment is not faithful to what our founders put into the Constitution and is not faithful to what Section 702 of the Telecommunications Act put into the Communications Act. And it's high time for that to be pushed back and for states to be able to step up and start stepping in to protecting our citizens. Second, I would agree, it is extremely frustrating that Congress has not been able to move forward in a wide variety of areas. Privacy legislation of some type, comprehensive might be great, but they can't even get kids' privacy done. You have a widely bipartisan bill like COSA, specifically designed to ensure that social media companies are responsible for the harms that they impose on our youth, passing out, I think, 93 or so votes in the Senate. 91 votes in the Senate, doesn't even get a vote in the House. That's the type of stuff that should easily be moving. You have other bills. Cosmo was recently introduced on a bipartisan basis. Lots of other bills that are out there, and they're just not moving. And it's in part because big tech goes in and they say, well, any of this is going to destroy innovation. It's going to destroy our economy. Literally everything somehow violates the First Amendment, and it will destroy the internet as we know it. And I will say I'm very happy that states are beginning to step up and fill in that void, that they're going to be willing to call BS what is in fact BS. And so I appreciate that in the work of the state of Colorado and others to actually help protect our children. Now, one thing I'll say here, and here's where I'm going to try to come up with some disagreement. You talked about cooperative federalism, and I actually don't feel like the normal cooperative federalism model has been all that successful. Look at the 96 Act. The cooperative federalism pieces of that today are largely dead because technology has evolved far past them. And you look at the BEAD funding in the IIJA. As Nick Alexander was explaining before, that very much gave a lot of authority to the federal government to put the guidelines around what's happening in the states. And 3 years later, we still don't have a single home, a single family connected. And indeed, many states still are working through to get approvals. That's not success. That's a problem. As much as I like many of the reforms from the ACA, the idea that we should have this fragmented insurance market so that if you move your house, you now have to go from 27 very hard to understand plans to 28 more, all with slight variations buried in 500-page documents. How that's benefiting the American consumer, I don't see it. And so the thing I do see working is what I will call complementary federalism. It's where states and the federal government, through political forces, are essentially forced to figure out who can actually do a better job of steering the economy and protecting consumers. Now, antitrust is one of those areas where there's effectively complementary federalism. Because I've seen cases where DOJ and the FTC begin stepping in, and they see the value in bringing state attorney generals on board. I've seen cases where state attorney generals, instead of just allowing merger after merger to go through, step up and say, no, this is insane. Why on earth, in this context, do we think that a company buying the supermarkets across the street from its own supermarkets is never going to raise prices? That's complementary federalism. It's not cooperative because it's not the federal government setting guidelines and the states implementing. It's complementary in that they're having to work together. The political pressures at the state level are forcing the federal actors to take consideration and act. And that, to me, has been a significantly good thing in the area of tech, especially over the last 6 or so years. One thing we've seen, one thing I know that my nonprofit is working on right now are age verification laws. And it's something that's long overdue. Now, the problem that a lot of states and a lot of tech companies have had with this in the past is a lot of these laws have been, I would call, heavy-handed. Every website or certain types of First Amendment websites or certain amendment unfavored or speech disfavored websites are required to do this. Even if you're age verified once as a consumer, you now have to do it again and again and again as you go to a different app or a different website. And of course, the small developers who are just trying to get a place in the market are not going to be able to compete and set up their own age verification, or then are going to get stuck paying huge fees in order to do it. So one thing that we've been working on with a number of states, ranging from Hawaii and Alaska to Utah, Texas, and Alabama, is looking at App Store age verification. The very simple idea. For most kids, you get on with one device today. For teenagers, like my 13-year-old, it's her cell phone. The App Store knows how old she is. In fact, Google and Apple have had previous consent decrees on looking at age verification. There's no reason they shouldn't be communicating the general age category. Is this an adult? Is this a young child under 13? To apps. It means the apps don't have to do age verification anymore. They can get that from the App Store. It means that consumers don't have to age verify every time they're going to a new app. It also means, to be frank, that companies like Instagram, who go out of their way to say, we don't allow 12-year-olds on our platform, and then do research on the benefits, as the Attorney General said, of getting 12-year-olds and 11-year-olds and 10-year-olds on the platform, where they then have to do that research in a way to make sure they don't actually identify any 10, 11, or 12-year-olds on the platform because they would have to kick them off under their own policies. Forces them to stop avoiding their responsibilities. It forces them to be honest with the American people. If you really don't want someone under 13 on, that's fine. You kick them off. But then you're going to have to actually deal with those ramifications. And you cannot just pretend that an 11-year-old can consent to 30-page terms of service and has no rights whatsoever because they signed up when they were under 13. So to me, that's the type of complementary federalism. And I'm very excited that states, not just for this type of bill, but other bills, are beginning to venture into the void left by federal inaction. And I'm hoping, as we've seen in previous situations of complementary federalism, that this will spur the federal government to start taking action and start figuring out how do we actually make sure that what the Attorney General says doesn't happen, that you don't have a law in Connecticut and a law in Colorado that conflict so that you can't follow both. But that's not quite what I would call cooperative. It's states realizing that there are real harms happening to their kids, to their families, stepping into the void and forcing the federal government to actually take action. But anyway, thank you, Phil.
Great. Thank you, Nick. And I should say this is my first time here at this flagship conference, and I've just had amazing, generative, and thought-provoking discussions with folks. And we're going to try to continue that on the panel today with hopefully a little bit more disagreements as well, so we get some heat. David, I'm looking at you over there. So we've been here many times before in this kind of place about what is the state and federal balance and trade, tech regulation. What should we do about it? We're at a moment, I think, where there's very broad public support, right, as we saw with COSA, for people to take action. And I think at the last panel, Arpan Surya said, it's the time to build version of government. We want government to do things for us, but it seems to be stuck, perhaps. And what are the bottlenecks that are causing dysfunction, where we're not seeing the kind of action that we would like to see to address the very real harms that we have? So we're going to look at it through three different subtopics. First is to look at historical examples to what can we learn from the history of different forms of federalism. Then we're going to move specifically to social media regulation, trying to think about how it works in that area. And then finally, especially with the amount of weight being placed on states to take action in the face of congressional dysfunction, is how do we build the institutional competence of states to take the forward-looking actions that society is demanding of them. So let me start perhaps with Lisa, a question for you. What kind of past models of state regulation should we look to unlock this new form of federalism that works for people?
So a couple of caveats. I am not Karen Kornblue, so I am filling in for her. She couldn't make it today. Any views I express today are my own. They're not the views of Ranking Member Pallone or the other Democrats on the Energy and Commerce Committee. That's particularly true since I had very short notice that I was going to be filling in. Second, for those of you who are wondering why somebody who's the chief counsel for something called Commerce, Manufacturing, and Trade Subcommittee is up here, traditionally this committee is known under the Democrats as the Consumer Protection and Commerce Subcommittee. That word commerce does a lot of work, whatever you call our subcommittee. But we are the subcommittee responsible for the consumer protection side of the FTC, the Consumer Product Safety Commission. That's the land in which we work. At the risk of sounding quaint, why don't we talk about telemarketing and do not call? Hasn't worked perfectly, but the landscape has changed radically over the last 20 years or so when it comes to do not call. It was the states who first enacted do not call registries. Florida enacted one in 1997. I think it's Arkansas and Alaska followed in 1998 with what was called the black dot laws, where companies were supposed to know that you didn't want to be called because a black dot would appear beside your name in the big old telephone books that people used to have. In 2001, the FTC moved forward with a proposed do not call registry, and when the FTC and then the FCC adopted that registry and those rules, it was described as more popular than Elvis, or more popular than the Elvis postage stamp, I should say. Maybe not more popular than Elvis. Two very different things, I know, but the Elvis postage stamp was very popular. So the states really were spurring on the federal government in a world where it really made no sense to have individual state do not call registries. But it took a lot of spurring to get the federal government there and to get the courts to believe that it was constitutional, quite frankly. There were real First Amendment questions. The FTC hired an outside First Amendment lawyer to work alongside the regulators on that case to do everything they could to make sure that they were, had good arguments in the courts around the First Amendment. Every bill, or almost every bill that goes through my subcommittee that gives the FTC authority to do something also gives the state AG's enforcement authority. That is just our practice. It's our practice on the Democratic and Republican side. If you don't see that in a bill, you should wonder what the politics are. But in our experience, the FTC and the state AGs are incredibly complementary in terms of working together and also working separately to try and occupy the field of consumer protection, which is unfortunately a target-rich environment, and so they cannot possibly cover every possible target. But they do have that experience of working together, and as technology gets more complicated, that gets more complicated. It means Phil and his colleagues have to hire more technologically sophisticated lawyers and technologists in their office, as does the FTC, as do other federal and state regulators. So that was kind of the long way around to saying, I think we have a history of lots of good cooperation, and we just need to keep leveraging the resources we have. And I'd like to say add to them, although I don't think in the federal government that's the budget environment that we're in.
Yeah. David, for you, what are some cautionary tales, right? Efforts where we thought maybe federalism and some kind of complementary or cooperative federalism would work, and then it hasn't achieved the results we thought it should.
Mihir, thanks for having me, and Brad, thanks for having me again. I think we were looking at some of these issues last year too on federalism, so they're not going away. But I would say an example that isn't working is one we talked about earlier, which is privacy. And this is not a criticism of any state privacy law. We have, what did we say, 20 state privacy laws. How many people in this room are reading their privacy disclosures? In this room, you don't have to raise your hand. Don't even embarrass them. But if we're not reading it, there's one back. Is that Jordan on my team back there raising his hand? Just to make me look bad. Just to make me look bad. But anyway, the point is, there's an example. You have 20 state privacy laws. On the disclosure on the Comcast website, because we operate in, probably the bulk of these 20, it's dozens and dozens of pages that no one is reading. So you say to yourself, okay, well, what's the big deal? But it's actually problematic, right? Because it gives a false sense that people are actually consenting, right? It gives a false sense of protection. And in reality, what it is just, I consent, you click in. Same thing with cookies now. And you have the European GDPR. So you've got all these things out there that aren't working. Now, I like the discussion we're having is if states are an incubator to start a discussion, sure. And you have 20 different states. And then you get the federal government, if it was better functioning, to sit down and say, well, how do we pick and choose among these 20 to really get a solid federal rule and then sunset these state rules? If that's what we're talking about with cooperative or, what was your version?
Complementary.
Complementary. Sorry, I can't read my own handwriting. If that's what we're talking about, then that's fine as a sort of initial stage to have this discussion. But if we're so we've done this in privacy and we see how ineffectual and really not terribly consumer protection other than litigation and creating a litigation bar around this. And I've got more lawyers working on privacy protection than other things. If we're going to go down this road now with AI, it's going to be similarly problematic. And other areas that are inherently interstate, Lisa, you brought up do not call registries, clearly interstate companies making interstate phone calls. So I like the way you described it, which is the states, it seems like, took the lead, and I don't know the full history here, and then the federal government stepped in and created a federal framework. That makes sense to me as sort of first movers, but not as end states for these interstate and now largely international businesses and practices.
Yeah. Chris, question for you in this, as we're seeing this sort of tension play out, right, where I think it's interesting, we're hearing about incubators and labs of democracy, but what we're really seeing in many ways, and General Weiser alluded to this, is a state-level effort to come up with their own frameworks and a comprehensive framework. Is there anything that you are excited about seeing as the states are going about developing tech policy that you think would be interesting?
Excited would mean I view it pretty positively, and there's some things I'm excited about. I'm excited about their energy. I'm excited about their responsiveness. I think I really enjoyed the first speaker where we had a real breakdown of federalism and the reaction. I agree that there's a real reaction to state and even local action when the feds are not active. And so I appreciate their responsiveness to what I think the people want, because I think the public largely feels powerless given what they are offered in the marketplace, in the technology marketplace. I'm not excited about the process. I'm not excited about the substance. Depending, it depends on the issue area. I'm not excited about the expertise. With all due respect to Attorney General Weiser, I think is probably the best of who we have at the state level. There was a description in our first keynote of different ways to look at federalism, cooperative, you name it. I don't think they were mutually exclusive. At the end of his speech, he talked about it being a scaffolding for national debates. I completely agree with that as well, and I think all of these can be true. And so what we find is that certainly from a public interest perspective, with groups like mine and others who have a mission to do what we think is good for society, we have very little power to impact state-level regulation. We find that our counterparts in industry are well equipped to dominate the viewpoints of state and local legislators. And in a way that we just can't compete with. And I think industry knows it. I was talking with a big tech representative who will remain nameless, but who was fully at the table on comprehensive privacy when we were pushing through your committee, Lisa, trying to get it passed. ADPA, a bill with broad bipartisan support that was killed by the Democrats out of the California delegation, and then not brought up again with the new Republican majority for totally different reasons. And they said we can live with a privacy regime where there are 4 or 5 different models in different states because they can afford to. And so they don't care about having comprehensive privacy pass at the federal level. Now, I don't think that's good for competition because a smaller tech company probably would care about that level of regulatory burden. We certainly care as a public interest org because we find that for as strong as, say, as Colorado's privacy law is, it is strong comparatively if you're judging it by, say, Obama-era standards. But that the push for comprehensive privacy in the last 5 years at the federal level is for far stronger protections that don't require the public just to accept what they're given in the marketplace and then opt in or opt out. It has data minimization, it has civil rights protections, it has things that would be much stronger than what we're seeing at the state level. And that's just privacy. We have folks up here with different views on all different topics. It's just an example, but I can, I find this dynamic really true across other issues. I could give you broadband examples. I could give you platform regulation and content moderation examples as well. AI for certain is a newer topic. And so we're interested in what we're seeing from Cal Compute and Empire AI in New York to drive towards more public AI and certainly open source AI development that we weren't seeing as strong at the federal level, but it's early in that game and the companies have yet to wrest control of the debate at the state level. So I'll wrap up by saying I actually really agree with General Weiser about the importance of delegation of authority and power to agencies. We were the first group to call for an expert digital regulator over digital platforms that still does not exist in this country. We are watching the expert regulator over broadband and telecommunications networks lose their authority after decades of being the expert in that sector. And we need expertise and resources at the federal level to keep up with the pace of innovation and get the balance of regulation right so that innovation can happen with guardrails around basic public interest principles. That is the role of government, to protect the public interest as these powerful technologies are rolled out. Public interest values like universal service and equity, competition, localism, privacy and consumer protection, free speech and content moderation, which go hand in hand with safety, which Nick was talking about, and people can have different views on it, but there's a balance to be struck there.
Yeah.
Nick, you want to add something?
Yeah, so I just wanted to add, I'm going to toss out something that may not be popular on this panel, but I really hate the phrase comprehensive. When you're describing privacy, when you're describing pretty much anything. Because the problem is, as soon as you start talking about the word comprehensive, people begin adding a lot of additional stuff to it. I remember when I first did a little bit of privacy stuff back in the early 2010s, and we were talking about kind of passing some kind of national privacy. It was really, the big focus was just opt in, opt out. And it was pretty simple, it was pretty clear. And the questions were, does it need to be opt in across the board or opt in only for certain things, et cetera. And I think one of the things that stymied federal efforts here is people do keep talking about comprehensive. And if you're talking about comprehensive, you've dramatically upped the ante for federal legislators. Now they have to take into account all these different things, data minimization. They have to take into account discrimination. They have to take into account I don't know. I mean, you go into some of these laws and you begin looking at it and say, how is this even about privacy?
Data breach, like the
yeah,
said.
I mean, and to me, I think this is one of the biggest problems is that like when, for capacity issues, one of the ways states work best is because they tend to have simpler, more straightforward things because they don't have the capacity to get too in the weeds and make things very complicated. At the federal level, there are lots of incredibly good agencies like the FTC, like the FCC, with incredibly good, dedicated civil servants who understand and can get much more in the weeds. But then again, as soon as you make it not about a relatively simple, here's what we're trying to solve, but here's all the possible things that we might solve in the legislation, it becomes so much harder in the legislative process for something to actually move forward. I mean, again, if you look at like kind of comprehensive reforms, you have things like the ACA, which is kind of comprehensive healthcare reform. It happens after a landslide election, like once every decade, maybe. And so, I would just encourage those who are looking for, federal privacy legislation or others, try to figure out how do you advance the ball forward without trying to do absolutely everything at once? And how do you make it so that people can recognize there are going to be more bites at the apple? So those who want more maximalist privacy protections can at least sign on to more minimalist privacy protections to start, which I think would still be better than the status quo.
So I'm messing up your structure, but okay. I feel the need to respond to that because I think Nick is mixing up apples and oranges. I don't disagree with you that there are pieces of the comprehensive federal privacy legislation that Congress has looked at that are pieces and that we could do in pieces. But I also think you're mixing up pieces and fundamentals. So it would be great if we did a federal data broker law, and that would be awesome. And all people in the United States should have the ability to opt out of data brokers selling their data. And that could be part of a comprehensive law or it could be a standalone. But suggesting that data minimization is a piece of privacy rather than central to privacy is wrong. And so I want to put a stake down there and say we have moved past notice and consent. Some states have not, unfortunately. And Paul Ohm's in the audience somewhere. He did a training for a bunch of people on Capitol Hill 2 summers ago when he said academics are really confused when we talk to policymakers who talk about notice and consent because all the evidence is notice and consent doesn't work. It's obvious to all of us, right? How many people have clicked through, yes, you can have my location, to somebody who has no business with your location data because you just want to get to the particular website, right? Like even those of us who are most experienced and thoughtful about what we do with our data give up our data all the time, either because we have no choice or because notice and consent is false. Go back to David Don's description of his own company's privacy policy, which is not different than others and arguably could be better because he has so many smart people looking at it, right? So I just want to reject the idea that piecemeal is the same as you shouldn't have basic concepts in any legislation you have. I also, Nick, I'm going to take the opportunity to completely reject the idea that we should give Google and Apple information about the age of every single American. They've been sued over and over again for a reason. They're not good actors here. So to suggest that that's simple, and I'm Nick and I are good friends. So when I say that to him, it doesn't undermine our friendship, right? To suggest, this is a shout out to the law students in particular. If something sounds really simple, stop. Sometimes it is. Sometimes people come up with great ideas and you think, why did nobody ever think of that? But sometimes it's not as simple as it sounds. And we're going to get to this maybe if we get there to the social media conversation. But when you think about how to put limits on kids, you should also be thinking about what are the privacy implications of any particular action that we take with respect to kids. Yeah. And kids are not monoliths, right? 2-year-olds become 13-year-olds, become 15-year-olds, become 16-year-olds who need access to reproductive health. It's not just 16-year-olds, right? Yeah. But so law students, take it all with a grain of salt and think about the difference between what's fundamentally important and what are pieces that you can work on separately.
Let me just add one small point. You didn't touch on that, which is comprehensive in this context means not sector specific.
Right. Okay.
So the current privacy regime is, we have it in financial services and we have it in healthcare. But healthcare is only for providers, not for other entities who collect healthcare information. So we need to create one that data protection is across the board. I think what you might want to amend your remarks, Nick, is you're okay with across-the-board privacy,
Oh, yeah.
and you're also okay with doing it stepwise. And then the final point, which you didn't necessarily say this, Lisa's point is data minimization, I talk about data protection assessments, have become part of the fabric of what meaningful privacy protection has to be.
Yeah, so let me just pivot to the social media conversation, because I think there's a large degree of overlap on sort of the policy problems here, right? We've struggled with privacy for the last 20 years. We recognize this big problem with children's safety online. Why aren't we going to go down the same path we had down privacy, General Weiser? What hope do you have that we don't repeat the privacy mistakes?
I think the stakes on social media are markedly different than privacy. People are creeped out that they go online and, wait a minute, I was just searching for something, now I'm seeing an ad for it. They wonder how this data broker is sharing their information and how someone can identify their email with their IP address, whatever. Like, that's problematic. We need privacy protection. Social media, we're talking about kids' lives. We're talking about a mental health crisis that's having material impact on kids' ability to learn, kids' ability to form relationships. We've historically seen action by Congress when the concern was access either to child pornography, which means kids are being abused, or kids having access to pornography. Those have been areas that have gotten attention. I think what we're talking about here is even more concerning because the dark holes that some kids are going down are devastating. So the reason I am hopeful and optimistic is because we have to act, and I'm committed that we're going to see state action. And if that's what has to solve the problem first, like you mentioned, do not call, fine. But ultimately, the rationale for federal action is critical. I take Lisa's points about concern about unintended consequences and how you do it. We've got to be smart, we've got to be thoughtful, and we need to be vigilant too.
David, when you look out at the landscape of social media regulation, one thing we were talking about is that it introduces, apart from a state and federal dynamic, you're introducing an international component to it as well. Could you speak more to what you think are the concerns there?
Yeah, I'm not, other than as a parent, I'm probably not very expert on the harms of social media other than what I see at home, which, too much video games, I guess. But it's funny, this discussion, and we keep almost going back, let's use privacy for a minute. There's really a call for federal action here. I think what Phil just said about social media is a call for federal action. And what we're all coming to terms with on this is that our federal government is largely, let's just use dysfunctional or dropping the ball or not filling the void or whatever we want to say. We said it about privacy, and now we're going to say it about social media, or we are saying about social media, and then about AI next, right? So the question is, though, I guess at a law school for this discussion, is the failure of the federal government to act sufficient cause or basis for the states to fill in the void in these inherently interstate services? You've got the interstate commerce clause, and then I'll throw on not only interstate, but of course international and global competitiveness. For me, I'd like, when you look at AI, for example, if we need if rather than having state-by-state balkanization like we have in privacy, if we follow that path in other areas, how effective are we and how competitive are we going to be? In AI, it could really stifle innovation and global competitiveness. We see the threats coming from other nations and trying to shape the rules and develop the technology. So what I find struggling, in this room is, in the room in law students, is we know the federal government isn't acting, but I'm not sure that's a sufficient reason to have each state kind of develop their own parameters, which in the end has really a thwarting effect of the innovative aspects of these. And I get the protection, and I want to table social media because I just don't know a lot about it. But when you see other things like AI and other innovations that are going to be hugely important and important to our economy, important to our global competitiveness, having states fill in the void is probably problematic right now. And I don't think a sufficient basis for regulation at the moment.
Yeah. And, the other side of social media regulation, Chris, this is for you, is that, while we're protecting children, we do pose some risks to free expression values that are really important. And there's been Net Choice and a lot of others have raised First Amendment questions to a variety of laws that have attempted to regulate social media. How do you come out as a public interest organization on these thorny questions?
It's difficult, and as I was saying, with what Nick was talking about, there's a balance to be struck. I usually start with that free expression. I don't think free expression works in our multicultural society without real competition. And if you don't like how social media moderates content, if you think it's too strong, then you should support pro-competition policy so that you have alternatives in the marketplace. If you like how they moderate content and you don't like some of the rollbacks that we've seen from Meta recently, then you should support pro-competition policies that give you options in the marketplace. That starts with antitrust, but it goes way beyond it. Interoperability on social media does not exist. It could exist. It's technologically becoming more and more possible. If you look at decentralized web protocols, that if platforms were built on them, could facilitate not only the easier movement of consumers from one platform to another without having to leave behind your friends and family. Basically, they call those network effects. But they have to build it that way. So interoperability, non-discrimination rules, stronger antitrust enforcement would go a long way to build the sort of choices in the marketplace that could then promote free expression and let people pick and choose where they want to be. If you don't empower the users of the platforms, then the power resides basically in a country with a First Amendment like we have. It leaves the power in the hands of the platforms. You need the check of the users in the marketplace. Or you can go the opposite direction and have a culture war that swings back and forth with the change in administration on how content is moderated, which we're starting to see right now. I think that's the wrong path. I would prefer a market solution. And I also am concerned about the change in kind of generations-long commitment to free expression and what it means. That it means that people who disagree with you have the right to speak, and that is hard on the internet because it's many-to-many interactive communication. It's very different from free speech concerns around cable television or telephone. And so it means that responsibility is diffuse, and where we can use competition to promote that, that's where you start, and then you can look at how you make things safer also for not just for children but for everyone. And there are ways to do that in content neutral ways that have been proposed that don't get a lot of publicity. Like some of the content-specific ways that we're seeing in some of the culture wars right now.
So, couple things. I think Nick and Phil both made the point that we know that social media companies don't operate in the best interest of kids. No kidding, they're companies. They don't know what companies operate in the best interest of their consumers. Very few, if any. And these companies have been sued over and over again by the FTC and by the state AGs just for engaging in deceptive and unfair practices, the sort of baseline of consumer protection law. We know that kids' interactions with social media have led to lots of negative outcomes. What we don't know is why or what the right solutions are. This is more complex an issue than any we've ever tried to tackle in the consumer protection world because the psychological complexity of it is beyond anything we've ever handled before. So those studies are going on. My feeling is we need to start with privacy, right? So part of the problem is that these social media companies suck up so much information about all of us and all of the kids who are using them, and then you weaponize that. So if we started with privacy and data minimization and limiting the amount of information that any company can collect about you to the information they need to provide the service that you have asked for, that it would be a good start. But we need more science on this as well. And so, again, a shout out to the law students, which is you can identify a problem, you can sue companies using existing law, you can stop them to the extent they will comply, or you can fine them, you can, right? But we also need good science and good evidence to support what they should be doing, not just what they shouldn't be doing.
Yeah. And maybe this brings us to the last aspect of the panel discussion, which is institutional competence, especially at the state level. You do need this ability to sift through different kinds of scientific information. You're going to get all kinds of studies thrown at you. You have different kinds of expertise. And Don, this is for you, as states play a more significant role in communications policy, where do you see sort of the opportunities and gaps in the capacity to regulate complex technologies, and what can industry do to help bridge those gaps that you see?
Were you throwing out too?
Yeah.
Who did that go to?
To you.
What's that?
Me.
Yeah.
You can phone a friend if you need it.
That's right.
Anyone else? Sorry about that. I was listening to the question and thinking about it. In Washington, I guess we don't get 5 seconds to think about it, but thank you. So, I think Chris talked about part of the problem, of course, which is we don't have 50 state legislators or 50 state attorney generals with the experience of Phil over here, right? And that's an advantage for industry, and presumably it sounds like a disadvantage for public interest groups. And again, counsel's again sort of doing this. And we're kind of biased in this room because we do have the attorney general who is expert on a lot of these issues, but that's not the case everywhere. So I think it's problematic on the expertise side. But, the flip side is not every state sort of shares the same perspective or values on these. And I know we pursued this a little bit last year, but, you call it expertise, but, California has expertise, but that expertise has different values than Colorado. And Colorado has different values maybe than Florida or Mississippi or New York. And so what ends up happening is when you go state by state on these issues, and if you're a company like mine, you try to find common ground, common threads, right? But they end up sort of being a blend or the lowest common denominator, shall we say, or maybe it's the highest burden. So all of a sudden, people in Colorado are burdened by what we have to do to comply in California, and we bring that here to Colorado, and likewise in other states as well. So it's really not, the issue of competence is of course critical, and I think that is a dearth of that at all 50 state capitals. But there's also the imposition of one state's values on other states in these questions, and really forcing that on others because companies, mostly in these areas that we're talking about, operate at an interstate and international level.
Yeah. And what's interesting about that is that some of the larger states have the resources to get the experts in, and then that's how they try to maybe set some of that default policy. The question is, Nick, for you, historically, the federal government has played a role, federal agencies have played a role in seeding their expertise with the states. What do you see the future of that?
I assume that would continue. It's as I said before, there are lots of extremely smart, hardworking individuals at the FCC, the FTC, and other parts of the federal government, and they really care about a lot of these issues. Now, to be clear, do I agree with them on all of them? No. But, I would hope that we would continue to see the federal government and federal agencies play a leading role in trying to provide that expertise. And I will tell you, this is one thing. Congress doesn't get a lot of respect. They haven't got a lot of respect on this panel. But one thing I love about Congress is you have any bill that's going to affect an agency, they go to that agency. And they don't just talk often to their legislative affairs office, but they talk to the actual subject matter experts. And those subject matter experts, in my experience, both when I was on Capitol Hill and when I was in the FCC, they would do very deep dives on the legislation. And they would say, look, you guys are the bosses. whatever your goals are, however much we might even disagree with them, we will still provide you the advice to try to improve this bill, to try to get it to a place to accomplish your goals. We may think those goals are wrong. We may think those goals are right. Doesn't matter. We're going to try to help provide the competence that might otherwise be lacking because we have that subject matter expertise. Now, if there are a way to open that up to state legislators as well, that would be amazing. And, I truly wish, my wife used to work at CSIPs in the federal government. And one of her jobs was to train not just FBI and Secret Service agents, but also various states on a variety of law enforcement compliance laws. And that's one of those programs that's great because it really helps bring that federal expertise to a wide swath of society. This is one place where cooperative federalism really does work. And I would hope that, in the future, that type of thing can be brought to bear. And I wish there were an actual kind of avenue. So as the state is looking at, across the board privacy legislation, notice I changed the word, whether that includes data minimization or not.
That's right.
Love you, Lisa. As they're looking at potential social media regulation, as they're looking at age verification legislation, as they're looking at trying to preserve public forums like various social media platforms for speakers who are otherwise disfavored by the establishment. Like, that's the type of stuff it would be great for there to really be an avenue for that federal expertise to be able to put into play.
Yeah.
There's a lot of value there that's just hasn't been tapped and hasn't been unlocked, and I wish there was a better way to get that out there. Maybe Phil has the solution.
Yeah, let me jump in. You're going to hear later from Alan Davidson, and this topic came up about the BEAD program. That's a great example of this, and what Alan worked hard to help do, and I saw it firsthand with my state attorney general colleagues, is build a community of practice among state officials. This is a big question about governance and how you allocate responsibilities, funding, and authority. I don't think the federal government doing the broadband program entirely from Washington was a good idea. I also recognize it's a responsibility here in Colorado or Louisiana or West Virginia to stand up and run a broadband office. I do this at the state level with local and regional authorities. How do we spend the $860 million we're getting for opioid abatement? We set up 19 regional councils. We build a community of practice among them. They can learn from one another. So this model of governance can be done. And my answer to your question about Washington is it better continue, because if you leave the states all on their own to spend this BEAD money without the support, without the training, you're not going to get good results.
Chris, were you about to add something?
No.
Okay. Let me just do.
Can I just add 10 seconds? Which is it? Oh, sorry. You go.
I was going to, but it was really more of a policy debate than really a federalism question. So, yeah.
So we're going to get to questions from the audience in just a second. But Lisa, you want to add?
I was just going to say all the things that Nick said about federal workers is also true of state workers. So state AAGs are an incredibly good resource for us when we're looking at consumer protection bills. We don't use them as much as we should, just because who has 48 hours in their day? But to a person, they are helped both individually and collectively. State assistant attorney generals are always willing to stop and do deep dives into our legislation and talk to us about how the real world impact on the ground of the cases they're litigating, thinking about litigating, have been litigated. So
yeah. So we're just going to do audience, please think of a question. I'm going to turn to you in just a minute, but we're going to do a quick lightning round, starting with you, Nick, and then straight down. Tech policy is evolved by witness here is a fascinating and rapidly evolving field. If you were graduating from law school today, what would be the first job that you would try to get? And then what would be the next job?
Honors attorney at the FCC.
Not a bad choice.
Easy first job. And then working on Congress in the House Energy and Commerce Committee, ideally, because the House is the one that does stuff, but possibly also Senate Commerce too.
Don?
I'm probably going to go against the grain here, but I think law firms do a great training for people coming right out of school. Rigorous, fact-based and legal-based. And I think when you start off in the policy space, where I now find myself, I don't think you get quite that rigor of the law that you need to build your base on. So I think a law firm's a good training ground if you can do it.
What's the next one, Don?
Come work at Comcast on the policy shop. If you're worthy there, come join us. We need the help.
Chris?
Well, considering there's a hiring freeze right now, so you can't get in at the honors attorneys program, people are laughing at that. Two choices. I agree with Nick. Capitol Hill is phenomenal. It's a real, sink or swim environment where you have to grow and show your skills, a variety of skills, and a great opportunity to do while you're young because it pays very little. And just,
Unlike public interest work, right?
Well, my second choice would then be you go to public interest, which pays a bit better if you stay in it for a while, like I have. But it's also a good first choice because, like a law firm, you have a great opportunity to develop and hone your legal skills. We believe in rigor as well, but you get a far more responsibility up front than a first-year associate does, where you get to manage coalitions, lobby, advocate, do all the other things that are involved beyond just the legal work.
Lisa?
So I feel that I've been well served by starting my career as a litigator. So I would recommend that if you want to practice law and do policy, you start there. And I started a firm, but going to a great state AG's office would be an option if you can get your way in there. The FTC is a great place to start when they have their honors program back. But really starting as a litigator is a great way to force you to look hard at the law and then figure out how you can apply it. And litigation is just really messy, which gives you a great appreciation for how messy life can be as a lawyer, no matter what kind of lawyer you're being. If you want to do policy, going to the Hill is great. I also think judicial clerkships are great. I realize that in some ways that might feel backwards, but I know a lot of people who did a couple of years as a litigator and then a clerk, and I think they were well served by that. But you really have to figure out what is it that you want to spend your time doing and then get really lucky like I have.
General Weiser?
Colorado Attorney General's office, of course. Clerkships, and then after a little of that experience, join a startup company.
Great. All right. On that, let's get questions from the audience, and we'll follow General Weiser's rule. Student first.
Thanks, everyone. So 2 questions connected. The first is to Chris's point that the power is in hands of platforms. Experts like Renee DeResta, Jonathan Rauch, and Shoshana Zuboff have written about the decay of the information environment. And then secondly, Lisa talked about reducing data as a way to decouple tailored algorithms from users. So my 2 questions are, what would work other than chronological feeds if data privacy laws were to come and take away the tailored algorithms that fuel social media platforms? And secondly, is it too late for Americans who have already been conditioned by predictive algorithms and find themselves embedded in tailored realities online? Is there hope for children if we do decide to regulate this? What are your thoughts? Thank you.
I'll answer the second one. It's never too late.
Right.
We've got to be hopeful that we can do something about what you put your finger on, the way algorithms are changing information's environments, increasing polarization and demonization. As for how important privacy is, that was a layup for you, right?
Yeah, it was. What would work depends on what the thing you're trying to solve for is. Like, if I'm trying to figure out how to replace the headlights in my car, going to YouTube and searching headlight replacement Honda CR-V 2015 works just fine, thank you very much. And I get a whole bunch of different videos that tell me, give me instructions, and if one doesn't work well for me, then the other one does. It really depends on what you're trying to solve for. Like, advertising is the thing we've had forever, and attempts to localize advertising have been a thing that works, but I'm going to just repeat myself for the 3rd time. Works in what sense? For who? For what purpose?
Yeah,
question. Oh, go ahead.
Oh, just add in, this can be studied. I'm not an expert in it, but there are ideas out here beyond, chronological feeds that can reduce people feeling like they have to stay on a platform forever, whether it's like not having an endless feed or other things. The Nudge Act, which went nowhere in the Senate, proposed having an agency study these things and then bring them forward as best practices in content neutral ways. So that and ending targeted advertising would be a good start.
Right, we had a question over here, I think in the middle.
Okay, I'll ask a sort of broad question, going back to David's point that just because the federal government is not regulating doesn't mean that states should fill that gap. Is there an area that you think states are very well situated to pass tech policy better than the federal government? Or is it really just truly they should step in as a stopgap measure for federal inaction?
Yeah, this is a hard one. I was thinking about that a lot. Fraud probably is an easy one to say the state has a role in. You want to say consumer protection, but that line starts getting harder to see on things. So where does the line get drawn? But I would say fraud is an easy one for states to exercise their policing power. And there are a lot of things you put under the guise of consumer protection, which starts, I think, interfering with interstate commerce and interstate development of this. And we want to be very cautious on that, I would say.
So one I can think of is experimentation with autonomous vehicles. The federal government is not prepared right now, excuse me to the sponsors of the bill who would argue with me, but to legislate broadly on autonomous vehicles. But there are experiments already happening in communities across the country on autonomous vehicles, and it's important that there are guardrails there. And so it's appropriate, I think, for states and localities to make sure those guardrails exist so that their citizens don't get run over, their fire lanes don't get interfered with. You know, all of the things that we can think of that autonomous vehicles would do as they're learning to be better and better at their autonomous vehicle.
Lisa, I don't disagree, especially, public safety. Obviously, that sort of falls in that category. But, you look at managing public rights of ways. It's very traditional local responsibility, yet if it's thwarting the deployment of broadband or telecom services, there's argument that there's a federal interest there. And the same thing maybe on autonomous vehicles. So you do have a public safety local component here, but if there's a city that bans them, is the federal government going to be okay with that if that's part of the future of this country?
Well, I was cabining it to when we're in this period of experimentation, in fairness. Yeah, I do think a city should be able to do that. I think, but I haven't given
entirely?
Much for now. Say, go experiment somewhere else. I don't want you to experiment here.
So two great examples of where cooperative federalism would be great, because I was going to use the rights of way issue as well. You're seeing, I think the rights of way issue is over exaggerated at the federal level. There's a real safety and even kind of aesthetic concern at the local level that should be deferred to local level. I as someone who worked in local government, there's a lack of resources to make the process move faster. And if it was cooperative between the federal and industry and local government, I think you could see rights of way happen faster because they want broadband deployed too at the local level.
Great. So we have time for just one question, but what we're going to do is let's have all the people who have questions raise them, and then the panel can decide which ones are not. All right, so go ahead.
Sorry. Chris, you talked on this a little bit, but how do you fix the public trust issue, given that half the country doesn't trust the government at any given time right now because of the algorithms on Facebook? You have two echo chambers.
Okay, public trust. How do we fix public trust? And then...
So for Phil, would you've specified dark holes as a major problem, and it seems like you're angling towards banning underage people from social media. No? Oh, okay, never mind then.
Okay. So that was
just gonna never.
There'll be a debate later.
That's right. Yeah. That's a debate.
That's not my solution. Yeah. I think we have to oversee it with guardrails, but it wouldn't be a categorical ban.
Okay, so two more quick questions, then we'll get going.
My question would be on antitrust and social media, and to spur both competition as well as interoperability, as we did with Ma Bell 4 decades ago. Would that work? And might that originate from the states?
Okay, last one over, the one over there and then one here.
Go ahead.
Would it be wiser for people who want to regulate social platforms to spend the next 4 years writing a Project 2029 and forget about immediate action?
Okay. You've been patient, so last one here.
Thank you. It seems like the two options we've been discussing is having the feds do something and having individual states do something. A mid-ground is the Uniform Law Commission, which has been around since 1892, have promulgated over 300 uniform laws like Uniform Commercial Code, Uniform Probate Code. What can their role be? Can we have state action, but uniform state action?
Okay, great. So we've got a whole host of questions that I'm going to try to boil down into one question, which is...
Public trust question was just to Chris. Let's go with that one.
I love that one.
Which is, there's a lack of public trust. Is there any hope for some unified attempt on the part of federal and state governments to fill that gap of public trust?
Chris, this is to you.
Okay. I don't believe it's a tech solution, and it's barely a policy solution. People don't trust each other. People don't want to share power anymore. And information and communications is power. And so until we get back to the idea that it's okay for someone to say something that you disagree with, and that they have a channel that allows that, whether it's Fox News or MSNBC, whether it's True Social or Blue Sky, I don't care what, then we're going to have a struggle over communications as if it's zero sum. So that's where I start.
Okay. Anyone else?
Yes, it's going to start at the local and state level. And so for everyone who's focused on the national level, I would encourage you to refocus. State and local officials have the ability to earn trust through transparency by actually showing up in real conversations. That's the way we're going to heal our republic.
All right. Thank you very much.